lawyers here and those who have worked with startups extensively. And for our last panel, we thought this would be fun to have them talk about some of the worst mistakes our startups make. And for this, I'm going to turn it over to David Lehman, who is with K&L Gates and one of our startup lawyers that we work with regularly. So David, take it from here.
All right. Well, thank you, Kit, and welcome everybody. And this is one of the more fun ones I get to do because it does a couple of things. One is we get to talk about all the mistakes that startups have made that we've seen. That's sort of fun, sort of make fun of people, keep it sort of lighthearted. And second is that you don't have to listen to me ramble for an hour and a half. So that's even better yet. So let me introduce the panel, and we did a little differently this time. I have two lawyers who I'll introduce in a moment, but the first panelist is actually not a lawyer, although he could play one easily because he does sort of from time to time as it corrects what I do. But Tom Peltzinger is with us, who I've known for longer than I care to admit. And he, together with Babs, who you just met, actually founded a launch site, again, longer ago than I care to admit, and Life Sciences Incubator, and now works with a company called Knopp. But I'll let Tom introduce himself and give him a little bit about his bio and his background. And I can't think of anybody else to talk about, better to talk about startups and both the good and the bad and the ugly.
And the mistakes. Well, thanks, David. Thanks, Kit. And great to see a lot of old friends here and meet some new ones virtually. In brief, I was a reporter and editor for the Wall Street Journal for 2.5 decades and got very smitten after moving to Pittsburgh from DC for family reasons with all the NIH funded research here. And along with that, started, as David mentioned, launch site and incubator to pull technologies out of the universities. Since that, or over the 20 years since then, we have 5 companies that are still operating. One has had a partial liquidity event. David Lehman knows that story very well. A couple of them we hope will have liquidity events shortly. We've raised across the portfolio with Knopp Biosciences accounting for the lion's share, probably about $200 million, maybe a little more. Of course, we've spent $200 million or a little more. And now at Knopp, which is where I hang my hat with probably about 80% effort versus the rest of the launch site portfolio, we are developing a late-stage molecule for eosinophilic asthma. And we have a preclinical program in potassium channel activator molecules that we are directing our lead candidate to a rare and profoundly disabling genetic epilepsy of neonates. So I fully admit that I'm a great poster child for mistakes that startups make. And David Lehman has saved me from a few, and David Kalson caused one or two. I'm very pleased to be here. Thank you.
Thank you. Let me go to Deborah Walker, who is with Innovation Works, which is plays a huge role in our in this ecosystem on helping companies get started and getting funded and providing them with a what they need to get started. And Deborah before that was in private practice. Deborah, I don't know how long you've been at Innovation Works, but it seems like it's been quite a bit. But
It has been. It's been about 13 years. Before that, I was with Morgan Lewis, first in LA, doing kind of base corporate transactional work and energy work. And then when we moved to Pittsburgh, I transferred to the Morgan Lewis office in Pittsburgh, which was very heavily involved in the kind of emerging startup scene. And from there, I worked briefly at a startup that was a client of the firm, and then that company was acquired, and then I moved to Innovation Works.
No, I didn't realize that you'd going to work for a company. Why don't you give them 2 seconds of what Innovation Works does, just for those who aren't familiar?
Sure. So we are primarily funded by the state, and we provide funding and business assistance to regional technology companies. Most of our investments are at the seed stage. We also have several accelerator programs, Alpha Lab, which is software, Alpha Lab Gear hardware, and then we just launched a new health science accelerator called Alpha Lab Health. And we also have several smaller grant programs.
Oh, thank you. And the last panelist, but certainly not least, is David Kalson, who's been working with startups actually just a little bit longer than I have. It's hard to believe. I've known him since we were, I think, in law school together, believe it or not. So David, why don't you tell me a little bit about your practice and what you've been doing?
Sure. And like Deborah, I started off in a more varied practice. Although I grew up in Pittsburgh, I started my career in New York in the mid-'80s. And when we came back to Pittsburgh, like all prodigal sons and daughters do eventually, like the swallows returning to Capistrano, I joined a firm that was a young firm, Cohen and Grigsby, a spinoff from Reed Smith, and continued that work. But I began to, my friends who were engineers, some of them at CMU, started to have great success. And it really intrigued me what they were doing. And as I got more deeply into their business, I realized that I had found my passion. I found that working with startups combined all the legal disciplines that I enjoyed. It also combined the business aspects of it, the counseling aspects. We wear so many hats, lawyers who do what David and I do. We wear corporate hats, we wear tax hats, we wear therapist hats. And that happens to make for a very interesting day. Every day is an interesting day, no one like the day before. So if you have a little ADD, it's a wonderful practice to have. And I've managed to sustain that passion for the last 25 years. It's a demanding practice working with entrepreneurs. They're brilliant. You all are brilliant. Some of you are easy to work with, some of you are not. The situations you face, some are quite challenging, but we all enjoy that, which is why we keep doing it. And just last year, our firm combined with Dentons, which is literally the largest law firm in the world with almost 12,000 lawyers in 77 countries. So to me, this is an interesting change because I'm continuing to do what I've always done, working with startups, mostly in Pittsburgh, but also nationally and internationally, and now working with colleagues across the country and across the world. So this is a new and exciting phase of my career, and I'm looking forward to it. But I continue to look forward to, working with this incredible ecosystem that we've built in Pittsburgh. And I guess my last plug is that lawyers can really get caught up in a zero-sum game, litigators fighting with each other. What David and I do and others in this field is we help to build things. So it's great to be a lawyer and to feel like you are actually creating something and not just dealing with people who are constantly fighting. So it's been very satisfying.
I agree with that. I echo that. That is the reason I decided not to go into litigation. I always say that they look behind them and they see blood and guts and dead bodies, and we look behind us and we see things we've created. They have a different view of that, by the way, but they're just wrong. That's all. So I thought what we'd do is maybe we'll talk a little bit about the various stages of a new company. So we'll talk about formation maybe a little bit, and then maybe we'll talk about IP, talk a bit about raising capital, strategic and exits, and negotiating term sheets. But let me start with an open-ended first question, which is when your startups come to you in the first place and they're thinking about starting a company. Maybe we could spend one moment saying, okay, so what advice do you give them in the first instance, and what do you see as sort of the biggest mistake they make? And I'll go first, which is, for example, I have a short sentence that I ask startups, and I tell them that if they can't answer this question, then they shouldn't go forward. And the question is, what are you going to sell to whom, for how much, and make money at it? And if you haven't thought about that question, then you probably aren't ready. Because it's amazing how many people have either a good idea. There's this wonderful technology in search of a business. They haven't really thought about what the product was, what the market is, and so until you've really thought hard about sort of what are you going to sell to whom, for how much, and make money at it, how much you're going to charge, was it really bear it? If you think about it, and that's really getting to a bit of a business plan, but I don't want people to go do a whole business plan, but at least think through, is there a business here? So that's sort of my little lecture, and people that don't do that tend to waste a lot of money sort of churning around without really trying to think hard about where they are. So let me stop there and maybe go to Tom. I'm putting people on the spot, by the way. I hope you don't mind.
That's all right. It's a panel, David. Concur completely. You stole one of my opening lines. But just to get this in early, and I'm sure we'll be discussing a lot more that's technical and operational, but I'm not sure first-time entrepreneurs appreciate the emotional rectitude that's required in creating a new company. As I mentioned, I used to be a reporter, and one of my last jobs as a reporter was writing about entrepreneurs. Part of how I got infected with this bug. And over, when I interviewed entrepreneurs, I would hear them say, "Oh, you can't believe what a roller coaster is." And then I became an entrepreneur, and it's like, holy crap, what a roller coaster this is emotionally. And it's even, if you have like parallel roller coasters with waves out of sync, there are times when you're way up and going way down. It's almost like a manic depressive corporate phenomenon. Part of that too is just the compression of time. So if you're coming out of an established business, you're familiar with processes, procedures, SOPs, and everything else. If you're in an institution, you're familiar with all that, and the infrastructure and software, as it were, that surrounds you. When you're in a startup, none of that exists. You're starting it from zero, from a standing start. And by the time you realize you have to do something, it's almost too late. It may even already be too late. It's like I'm sure there are some people with physics training in this meeting, so I say this advisedly, but it's kind of like the singularity, or a system that is under so much pressure that reactions that usually occur sequentially occur simultaneously, like the Big Bang. That's a startup. It's a big bang, and you've really got to be ready for it, and you have to make sure your loved ones are ready for it too.
Yeah. And how do they know? I mean, Tom, how do they know that they're the right person for that? I will tell you that we have clients that come through, and I look at them and say, and you talk to them and say, you don't have the more rectitude. You should be working for somebody.
It's hard to know. And in my own case, I'll tell just a little story. Babs and I were partnered. And Babs had a neighbor who is a sort of an occupational psychologist. And when I was thinking about becoming an entrepreneur, I went to him and he administered a battery of psychological evaluations that in combination were oriented toward entrepreneurial phenotype. And basically I got a D- on that assessment. And so of course I did it anyway. So I'm not sure it's possible to tell, David.
Yeah. But it's good for people to at least acknowledge that it's there, and ask yourself that question. You're going to be comfortable with it, or maybe ask your spouse. David, what do you think?
Well, I asked the same question you do, David. And part of that is just we work backwards, don't we? We sort of see where this company may be going, and that helps to inform how we started. I want to, before I get into this answer, I just want to say I'm looking at Deborah, I'm looking at Reed, Babs, people that I've worked with, over the last 25 or 30 years, Don Morrison. One of the reasons that we've worked well together is there's a sense of teamwork. Even though we're representing different interests, we're working collectively. What I ask entrepreneurs when the team comes to me is why are you doing this together? Why is this particular group coming together to do this? What is it about your history of working together, your particular skill sets, makes you think that you have not just the individual rectitude, but the team approach and commitment that's necessary to make this work? And is it too early to throw in the big mistake here, David, or this?
No.
Okay.
Yeah.
So
Because we'll come up with more.
All right. So here's one. A client came to me, and this was through Alpha Lab. And Deborah, you're going to remember this. They met each other at a startup weekend. And if you're familiar with startup weekend, you throw people together who have never met each other. You break out into teams. You come up with an idea. You come up with a business plan in 48 hours, and then you're judged. And the winner gets something. Maybe they get some money. They certainly get recognition. Well, this group decided they had a pretty good idea, and they were going to actually form a company. They had worked together for exactly 48 hours. And so they were good working in 48 hours to come up with a business plan. But in terms of their personalities, their skill sets, it was a terrible fit. And that became evident pretty soon after we launched the company. And, we did our best, as we do as lawyers, to put agreements together to try to anticipate when something isn't going to work out. But unfortunately, when something doesn't work out, people are not so rational as to say, well, I know what this agreement says, so I know where I stand. No, people get angry, and there are bitter recriminations, which is not a way to start a company. And, ever since that experience, I've been so sensitive in trying to find out, do you have the right team? Do you have the right mix of personalities? Do you have experience working together? Who are you going to have to bring in to complement your skill set? Are you willing to be flexible? There's a lot of questions to ask, and I do ask them. And are you prepared to be flexible? Are you prepared to make that commitment? And it gets them thinking, because they probably really haven't thought it through that carefully. So that's definitely something, David, that I like to find out early on when I'm meeting with a would-be company.
Yeah, that's a good point. It's interesting. And we've all seen sort of when those personalities go awry, how bitter it can get, and the divorces are really nasty. I mean, we all have had experiences where the relationships broke apart, and it's not unlike a marriage where it gets really bitter and it's difficult, and taking it apart. And so thinking about hard if it's the right relationships going in is really huge. So I agree with you. Deborah, any thought? Yeah, good.
I was just going to say, I'm not
go
on the
ahead.
panel, but I would just say that one of the things we get our startups to do is to figure out what the equity is. We use the Frank Demler's pie exercise, and I've had teams that can't even get through that. I said,
Yeah.
if you can't resolve that at this stage, I said this is never going to work. Anyway,
Well,
sorry, David. Yeah.
Well, but I think that's right. I mean, part of what you look at, I mean, I do is, I'll give you an analogy. If I'm having real trouble on behalf of a client negotiating with the other party an NDA in preparation for a strategic relationship, whatever it is, and we're having real trouble getting through the NDA, that tells me what this is going to be like when we for the overall relationship, right? So if you're having trouble at the beginning figuring that out, that's easy compared to the rest of the stuff they're going to go through. So I think you're right. It's a litmus test, almost. Deborah?
Yeah, so I was just going to say I'm in a little bit of a different position because I represent Innovation Works, so I don't advise companies. I kind of see them through the lens of doing the due diligence for Innovation Works in deciding if we're going to move forward with an investment. So this is kind of a shout out to both of the Davids. So the worst mistake I see off the bat is someone using the wrong attorney. And like my heart sinks when I hear someone say that there's, some relative has helped them form the company, because 99.9% of the time, that person is not familiar with the startup world. And they may be a very competent attorney, but there are very unique aspects about a technology startup that if you don't kind of appreciate those elements and build them into your plan early on, it's not like owning a candy company or, running the family business. There are different elements that you have to build into the plan. And so to me, that is the critical first mistake.
Yeah. I agree. I mean, we often tell, I'm agnostic, I'm slightly, not quite agnostic, but close to agnostic about which of the startup lawyers in town people use. But it'd be nice if they use one of them. Because I always say, I think that Edgar Snyder is brilliant. I have my hats off to him. I have a huge amount of respect for him. But I wouldn't hire him with respect to a startup company, right? That's just not what he does for a living. So your point's well taken.
And further to that point, there are, I don't know if it's a handful, maybe it's a little more than a handful now, of people like David and me who've been doing this for most of our careers. We've worked together, and we know how to collaborate. We look out for our clients' interest, but we know what to negotiate and what not to. We know what matters and what doesn't matter. And that's how we get things done. Again, getting back to the theme of we're building something here. We're not trying to wage war against each other and prove to our clients how brilliant we are by spending 10 hours on a 3-page document. We're trying to get something done. And when you're working with lawyers who you know and respect on the other side, it's not that difficult to do. But then you get someone who doesn't, and you spend hours actually educating them on how this should be. And maybe they'll get it and maybe they won't.
So Davids or anybody over here, we have a couple questions in chat. So we just got one. How critical is it to have the right attorney or even an attorney at all if the person is starting an LLC as a single founder?
David, you want to grab that one, Dave? Go ahead.
I was just talking. Why don't you go ahead and you can take this?
Yeah. So I'm going to say it depends. If you're doing a single member LLC because you don't intend to take in other partners, basically you can do a sole member LLC because you're going to do a lifestyle type company. And you're going to sort of, open up a restaurant and you're going to be the sole member and all that. I actually don't think it's all that essential. I think there's not the kind of complexity that you're talking about. If on the other hand, you intend to along the way, either take in additional capital, take in other people, investors, have other founders, or I'll call it be a high growth company, then I think it's essential, because then I think you're setting up the stage for the future. And that seed that you've planted needs to be right in the first instance. So in large part, it depends on what you're going to do in the future. As an example, in that case, maybe an LLC isn't the right thing for you to do in the first place. And I want to think about that before you even start. If for example, you intend to take additional capital and you're going to fly with this thing and you're going to take venture capital, it may be a better shot to be a C corp and get your 1202 for tax reasons and get that started right then. So it might actually make more sense to be a sole member, sole shareholder of a corporation. And unless you're thinking about that, you may not think about that question.
Okay, so there's one more in chat. How do projects such as Wikipedia fit into the business framework? And that, David, that was in relation to your opening remarks. This was a question to David Lehman and the thought on what are you going to sell to whom and for how much? So social enterprise type of thing, I guess,
Yeah, so that's fair. So I get that, but that's part of my point, which is, okay, so if you're going to do that, how are you going to make money at it even doing that? Is it going through advertising, or are you going to do, where's the funding going to come from? So, even in those kinds of cases, I mean, we have lots of clients that decide, okay, we're just going to do this and people will come. But then how am I going to exploit that? If not, I mean, is it going to be a money-making enterprise? Am I going to be able to sell advertising? Who's the market for that advertising? At that point, the product becomes sort of, is it going to be a subscription-based thing? What are you going to do there? So that's part one. If on the other hand, what we're talking about is something it's not for profit kind of enterprise. I mean, you're going to do something not for profit. Well, that's a different kettle of fish. But if it's a for-profit enterprise, my position still stands. So that is, okay, I'm going to build the website. I'm going to build this thing. People are going to come. But then who's going to advertise? And am I really going to be able to get enough people on the site to be able to sell it and monetize it?
So let me add on to that, David. And this is getting back to the team. Pittsburgh is really technology R&D centric. We have so many wonderful technologies being developed at CMU and Pitt and people who've left other organizations. We're very strong in that area. We are not as strong in the marketing and sales area as some other technology hubs. Look at Boston, Silicon Valley, Austin, which attracts the other critical team members because they know if their company is sold, there's 15 or 20 just like it, and they can join another company. We're getting that now with robotics. We're really getting that critical mass. But the fact is, we don't have as many really sales and marketing oriented folks as we would like. And so a lot of the companies that start are all technologists, and there's no one there to do the kind of analysis that David just did. We can do this to a degree, but to have the right people on the team to figure out how to monetize those assets you're developing is absolutely critical. And you have to get them on sooner rather than later, because eventually you're going to have to attract some capital and you're going to have to show people there's a market. And if all you've done so far is create a prototype, but you haven't figured out whether there's a market for it or how you're going to do it, it's tough to raise money.
Or ultimately liquidate it, sell it.
Right.
Yeah. All right. Other things before I move on to a new topic. That's great. So I was thinking about in the formation, we touched on formation about LLC versus C corp, and so there's that decision. There's the shareholder arrangement, the arrangements between the founders, and buy sells that we sort of touched on just a bit. We've talked about and there's vesting arrangements where you want to make sure that the founders vest over time, so the next day one of them doesn't walk away and he doesn't have it, and they own half the company or something. And those kinds of arrangements. Let me sort of turn to Deborah. So these companies come to you, and they're at the stage where they've been formed. I mean, you get them right after they've been formed. They've sort of started, but they're also, you're the first stop for raising capital, essentially. So when you look at these companies, what is essential, and what mistakes have you seen them make in coming to you besides hiring the wrong lawyer?
Well, so I will say a mistake we learned from very early with the Alpha Lab program. It was our very first cycle of companies. And at that time, we favored vesting, but we didn't require it. And we had a team, a 4-member founder team that elected not to have vesting. And literally 2 months later, one of the 4 members decided to pursue another opportunity, and they spent the remainder of the program in very bitter negotiations with that individual, trying to work out some sort of acceptable, they could not, you can't have 25% of the company's equity tied up with someone who's just absent. But it took all of.
Did she freeze or did I?
Of the company's energy on, we now require vesting for any multiple member team.
Deborah, I'm sorry to interrupt. I'm really glad to hear you say that you're forcing that issue. I think Babs would tell the same story I would, but we, before founders really made a practice of that, when we formed our incubator, we divided ownership not equally, but divided, everyone had a material share among, I forget exactly how many, probably 7 individuals. And over the course of the years, there's been a spectrum of involvement from mine and Babs's to people who just disappeared. And they're still in the cap table. And we make distributions and I sign checks to them. So it's a bit of an overhang, and I'm just trying to put an exclamation point on what you and David Lehman are emphasizing.
So let me ask you a question. So I'll go one step further on this vesting thing. We talk about vesting, and we talk about losing the piece that hasn't vested yet. I sometimes recommend to people that even for vested stock, you have a right to buy it back. And so you take them off the cap table, Tom, entirely. And so the argument is they're entitled to the value from the time they came in to the time they left. And so I'll buy them out at fair market value when they leave.
Yeah.
But they don't get to keep that lottery ticket after they leave. And that's a very controversial concept. And I have trouble getting my clients to buy off on it. They're sometimes they're thankful later that's there, but that's sometimes a difficult thing to get.
Well, I know of one of your clients that adopted that in its operating agreement and has used it to very good effect.
Yeah.
Where individuals who are vested, nevertheless, may be required to sell back to the company, but not in a way that deprives them of the value that was created while they were present. So yeah, I'm surprised to hear it's controversial. If you ever want someone to back you up on that, David, I'm here for you.
Well, I'll tell you who I think it's controversial for. People who feel like they've been screwed in their last company because the board used it to take them out when the value was still relatively low, even though everyone felt understood that this company was really going to take off. And you could employ the valuation techniques. You can provide for that in the agreements. Sometimes it's at the board's discretion. Sometimes it's the board's discretion in good faith. Sometimes you bring in a valuation. I mean, there's a million ways to do it. But the bottom line is early on, you're not going to have that big valuation. And for people who haven't been through that experience, it generally makes perfect sense. And I definitely, like you, David, offer this to my clients. I suggest that they at least think about it. But I've had several who you can just see them stiffen when you raise this because it's been used against them.
Jump in, David, do you mind if I jump in and sort of second a little bit, or both Davids? Because
Please.
I think the thing is, we had sort of, I won't call it necessarily a negative experience, but it was a learning moment, shall we say. And I think that when people are stiffening and saying, oh my gosh, it's because it's sort of like, it's never going to happen to me. I mean, he might get cancer or she might get cancer, but I'm not going to get it. And, they just don't think that it's going to happen, but it does happen so much. And the thing that I've learned is that if you don't stay actively engaged with a company in most cases, then you're just not going to be able to sort of keep that equity, because the company's going to need to move on. And if they need to move on, they may need to raise more money. Like if you're not operationally a part of it, it's challenging. And I think that's the thing. I think people think that they, give so much at the beginning, but then the real work is building the company over time. And so I think it's a hard thing to, to get across at the early stage when people they still have diamonds in their eyes and they think everything's going to be hunky-dory. But eventually, when push comes to shove, bad things can happen. And I do think that vesting stock at the beginning is a way to diffuse any tension, because, hey, if you stay with it, no big deal. You're going to get everything that you rightfully deserve. So just some thoughts.
So I'm going to pile on in this to give you a specific example. You all probably know him. You did go through Alpha Lab, that he had a partner in his prior company, and that the partner wasn't doing anything, but he owned 50% of the business. And so sort of eased the partner out. But there was a clause in the contract that you had to buy him out within a certain time of after he left. And his lawyer advice, he had a litigation attorney, and then he also had a friend who did some kind of family law or something. And he said, do I need to do anything else? Not really paying attention to that timeline. Well, he had to go fix it when an investor came along and said, what is this person who has all this equity and they aren't even around? It says, you fix it and I'll invest in you, but not until you fix it. So the former partner, a little bitter, said, okay, pay me $50,000. Whereas if he had actually done the buyout in time, it would have cost him something like not even $3,000, because the company didn't have the value at the time. So he ended up having to pay it. And
the thing is, you're generally buying people out of their vested equity for fair market value. Like I said, however that's determined. Sometimes there's a discount depending in the manner in which people leave. But anytime you start talking about for cause in any of these situations, the whole thing blows up. Right. So, even if you have the legal right to do it, you don't do it because, who needs now and other people threatening litigation. But the fact is, you do have to pay to buy out the vested equity. And even if the price isn't that much, it may be that the company just doesn't have the cash to do it. So there may be, a business decision you have to make about whether you're going to do it. Or maybe you can buy them out for a note rather than cash up front. Correct. So you can pay them out over a few years. So there are ways to structure this in to try to make it fair. But I agree that ultimately having a lot of equity, we call it dead equity, not debt, dead equity on the cap table is tough when you go out to raise money. The investors want to see that the bulk of the equity held by the people who are in there really making this company happen.
David, there's a question in chat. It's too long for, I can read it out loud if you prefer.
Well, let me just wait a second.
Okay.
Sorry, I'm going to read while you.
Well, could you talk about some various vesting models, e.g. over time versus performance-based?
Yeah, so there are different, in my experience, anyways, others can weigh in. We have different models. They include, and I'll do three. One is based upon just pure time. And you can do, sometimes people have a year cliff and then a period of time, 3-4 years, pretty common. Some people have vesting monthly, sometimes quarterly, sometimes annually. But there's time-based vesting. The second is performance-based. So particularly if you have somebody who's has a certain job, whether it be sales or perhaps creating a prototype or science or whatever, but they hit certain milestones. And so you can have milestone performance-based vesting is one, and we sometimes use that. I find it to be, I will tell you on that one, that works better for more advanced companies. For a new startup, it's hard to figure out what those would be based on. So I do time-based, because if you figure out what those milestones are going to be in the first instance, you'll be changing it like every, the next day. So it's not particularly helpful, with the exception of maybe capital raise. Sometimes you say, okay, if you raise so much money and we're involved in that, maybe we'll invest the money. But generally, I try to avoid it with startups. And the third one is sometimes people can't figure out quite how much people should get in the first place and how much effort they're going to do. So sometimes they do it based upon the hours spent. They say, okay, here's how much effort I put in, and therefore I'm going to invest based upon that. And that's kind of complicated too. At the end of the day, I have one philosophy which I've taken me a long time to come to, which is that simplicity is our friend. Anything that gets complicated under my scenarios 1 or 2 will come back to bite us. We'll end up having to renegotiate it and change it a billion times. So I have come around to, with startups, just doing time-based and forget the rest of it. And the parties decide to part ways along the way, then that's going to stop the vesting, because they won't have done the other performance or other things that they otherwise would have done. So that's sort of where I've come down over time on the type of vesting.
Can you talk about?
I'm sorry, go ahead.
I was going to start a new thread there, following up on something you said. After you talk, then if you could talk a little bit more about mistakes startups have made with forming their boards. So, David, I'm sorry I interrupted you.
Well, I was just going to echo what David said about performance vesting early. Business plans are organic, companies are organic. It's tough to do that. I think keeping track of hours, we've tried that. Sometimes people don't trust the other people, which is not good, because it just adds to this element of mistrust when you all need to be, pulling on your oars and at the same time in the same direction. And maybe a better way to handle it is just to recognize that someone's not going to be as engaged and they should have a smaller piece of the equity. And if they become more engaged down the road, you can increase their equity, albeit it's not founder stock. It may not be the most tax favored thing in the world, but
that's okay.
But if someone demonstrates real performance and that they're incredibly valuable, they can get stock options or profits units or whatever it is that you're using to engage them. Sorry, go ahead, Kit.
I just talking to you, if you have any good examples of bad mistakes that startups made in creating their board.
So I'm going to. Yep. So let's expand that a little bit to boards, boards and boards of advisors, and et cetera. So let me, and I'll give you one thing that people do all the time, which can be misleading. Some people say, I'm going to let other people talk about the composition of the board in a moment, but some people say it doesn't cost me anything to give people board observer seats. So they give those out like candy. And it turns out that board observers can take over a room, and a wrong board observer can actually make a company. And I've had this happen, and one that comes to mind, where there was a very aggressive board observer who would come and would do far more than observe. And basically, you would have thought he was the chair of the board and founder and principal funder and the boss. And while not everything's quite that extreme, I think one needs, when they permit board observers to look at how's that going to mesh with the operations. Is it really, that personality really going to work? Is it going? And so that's my one concern on this giving out board observers to anybody who happens to walk down the street or put in a couple bucks on that side. So that's sort of off to the side because I've just seen that happen. But on board composition, I don't know, if, Deborah, have you seen anything weird on the board composition side that the companies that come through?
Not at the very early stage. Farther along, I've seen, problems, but I would say tied to the board member advisor issue is kind of an equity issue in being inexact, that's often the compensation that the company will offer to a board member or an advisor. And often it'll be like 2% of the equity. Well, as of what date, right?
Yeah.
Now, a year from now, that's actually a fairly common mistake that is very problematic.
This is a great discussion, and I didn't appreciate it. It took me a number of years to appreciate, after forming a number of boards, how essential directors are and the criteria for composition. You want directors who will help you, who will help the company. That begins with opening doors. Directors, if you select investors who have access to money, access to markets, access to partnerships, and it's understood up front when you're recruiting them that that's the value you see in them, then it's going to be a meaningful membership on your board of directors. They have to understand that there's a time expectation and a role expectation. They have to be ready to do the work. It's not just showing up at a quarterly meeting or even a monthly meeting. It's using their networks. It's thinking things through. It's maybe reviewing your business plan. And then it's important that they really fully understand fiduciary duty, that they're not just in it for themselves, for a little slice of equity, or even for you because they like you. But if you have other investors or if you have creditors, that they fully understand they are on the line legally. And that self-selects a lot of people who aren't willing to do the work, who aren't willing to hold you accountable and that sort of thing. Final little speech here is diversity. It's a lot easier when you start to have some diversity, demographic diversity on your board of directors. It's, I look at the boards of one or two of our companies and I see, a half a dozen middle-aged or greater white males. And it's almost embarrassing in this day and age. I think it's really, really important that diversity is a priority from the beginning when you're putting together a board, not to mention your team and not to mention your staff.
Let me make, so we have a question in the chat room. So let me just to step back for a moment and describe for the group so that what we're talking about is there's the board of if it's corporations, the board of directors. If it's LLCs, the board of managers. But this is the board that governs. It's appointed by the ownership, and they in turn appoint the officers. They make the major decisions regarding the entity. Each board member has a fiduciary duty to the company. They have to do what's in the best interest of the company. That's their job, and they have to, that's their fiduciary duty. So when you take it on, you're subject to that, and it comes with liability. to shareholders, or if you don't satisfy that fiduciary duty. So it comes with potential liability. It's not just it's just not a name on the resume. Let me contrast that if I can, because there's a question on the advisory committee is something different. It's an advisory board. They're not a governance. It's an advisory board. It's like hiring a consultant. It's a consultant with a different name. It's a group that either an individual or a group of individuals that come together and provide advice to the company. They don't have a fiduciary duty. They don't have it's a purely contractual arrangement, which means, by the way, that it's even more important that those people have, for example, non-disclosure agreements because they're not subject to confidentiality, invention assignment agreements because what they create you own, and so it's purely there's no law around it, whether it be statutory or otherwise, governing that relationship. It's purely a contractual relationship. So when you have an advisory board, it's important to have, as Deborah said, clarity on the compensation they're going to get, or even and the arrangement that they're going to have and the role they're going to play. So,
Dave, I have two comments. Just this was a great discussion of this, and I hope people are enjoying it and listening carefully. It's a wealth of experience here. One is that advisory boards it depends on industries. And the life science industry in particular tends to have scientific advisory boards. And that helps to lend the credibility to the company, depending on who's your board. Mm-hmm. And some other businesses don't lend themselves as well to having an advisory board. The other, I guess, mistake or concern that I just want to mention about boards, particularly in early stage companies, are contractual board seats. 3 founders each have the contractual right to appoint a board member. Well, those are going to be your initial board members anyway, so it doesn't seem like such a big deal. But if you haven't crafted it really carefully, and even if you have crafted it carefully, it can be difficult as the company evolves and matures. And it's clear that there are people who should not be on the board. They should be off the board. They don't have to leave the company. They're still very valuable to the company. They shouldn't be on the board. And you want to bring in those people that Tom was talking about, who can do what the founders can't. And those contractual board seats can really be a problem. They can really result, again, they can create a rift where there shouldn't be one. And if you don't have those contractual board seats, it's the majority who's going to appoint the board or remove people. And then it really comes down to, well, who's the majority? But I've definitely seen issues, not always, but sometimes.
I agree, totally agree. And as I'll remind you again, if somebody has a contractual right and you want them to waive it, the question is, will they waive it? The question is how much. So because you got to pay them for it. So at least perhaps there's something, whether cash or otherwise.
That's a great point, David, and it applies not just to board members and others, but to other contractual arrangements. For example, a license. When you're pulling your technology, including your own technology, out of your institution, you have to be really mindful of how that contract is going to affect your ability to transact with other parties in the future. And that's a hard thing for someone who's naive in transactions to contemplate. But it's another reason why you need a lawyer to anticipate what your next chess move or what your third chess move is going to be, so that you are not restricted and therefore going back to your licensor and saying, oh, well, we need to amend the license. Of course, you'll be happy to amend the license, and they'll say, sure, that'll cost you $500,000.
Right. Yeah, right. Or we'll increase the royalty, or
yeah.
Right.
So I just want to make the point of distinction. We talked about board of directors. We have the board of advisors, although I say don't call them a board. But what do you do with somebody like a Don Morrison, who is very generous with his time and with giving advice on branding and retail, but he's not per se on a board, but you can go back out to him and ask him additional questions. He's an advisor. So do you view them differently, or, are there mistakes with just having people give you advice?
I think that's a consultant, perhaps. I mean, you can, there's nothing undignified about being a consultant. You can certainly call that person an advisor. And if that person is part of a group, it's a board of advisors. And David's right, in the life sciences, particularly when you enter the clinical phase, boards of clinical advisors are absolutely essential. But to David Lehman's point, when you're engaging those advisors, whether you call them consultants or not, they have to be subject to a contract that not only specifies their compensation, but their confidentiality. Mainly confidentiality. And I'm involved in a situation now where we are expanding our scope of confidentiality, and it relates to whether those derivative parties are subject, even though there's a confidentiality agreement between them and a third party, is the third party covered by our original CDA? And all that's really important. Invention assignment is the other one, because your consultant or advisor should know the fundamental details of your business and technology, and that creates opportunities for invention. And as Reed will tell you, an inventor is an inventor, regardless of any contractual relationships. So you need to establish the assignment or ownership of those inventions in your advisory relationship.
And what can get tricky here? I mean, we're speaking at this university. The universities play such a critical role in the growth of the Pittsburgh technology ecosystem. Don happens to be a free agent. Don can work for whoever he wants, and he can invent things, and he can agree to things, and it's whatever, they're free to contract. What can be tricky is when you're dealing with university advisors, whether they're at CMU and Pitt. Each of these institutions have rules about what their faculty can do. Pitt's happens to be more restrictive than CMU's. But this is where you really need to be working with lawyers who are used to dealing with university spinoffs and university policies to make sure that you're setting up your arrangements in a way where you're not putting the company at risk, or frankly, them.
So that sort of moves into a little bit of, let's move into sort of employment issues.
Before we go there, David, can I?
Yeah, please. Yeah, well,
somebody called me consultant a little while ago. I've been called much worse, by the way. I am on a lot of advisory boards, a lot of student teams, which I do gladly and freely. I'm also an advisor to companies that are a little bit further along from the typical student incubators. And when teams ask me to stay engaged, we have, usually it's an informal agreement. I don't think I've got any written agreements with anybody. Maybe that's my mistake. Maybe I'm too trusting, but typically what I encourage them to do is put together an advisory board, and I would recommend this to all startups. At Blue Tree, we look at companies that don't have a formal board. Board of directors are typically investors, and the advice I give all entrepreneurs is choose your partners in life wisely, particularly investors, because if you don't have a good alignment of vision and goals, it's just a miserable relationship from the beginning. But from an advisory board, there's a lot more freedom of who you ask to be on your advisory board. At Blue Tree, a dream advisory board for us is, find someone with domain expertise in whatever field you're in. If it's a medical device and you have a heart valve, find the head of cardiac surgery at UPMC or something to be on your advisory board. Find someone who's got business development experience, someone who's taken something from an idea to full commercialization, because they know where all the potholes are in the entrepreneurial expressway. And then depending on the type of business, it might be a technical advisor if you've got a manufacturing product, or if it's a sales play, you need someone who's really good at sales and marketing. As David said, there's a kind of a lack of that kind of expertise in the area. But those are the 3 or 4 main advisors to have. And the advice teams is when you get to that point where it's more than just, can you be listed as an advisor for, for a business competition or something like that. I say, you want to raise a profile as high as you can to get the best advisors, because you're getting 2 things from them. You're getting strategic advice on how to grow your business successfully. But more importantly, you're getting the advisors to open doors for you that wouldn't otherwise be there. They're going to make introductions for you and connect you with people. And that's really, the value. And, in return for that, what I usually suggest to companies is to consider giving the advisors, a very small percent of the stock. Don't give it outright, make them earn it, have some type of vesting schedule, over a period of time to make sure the company's getting the value out of that advisory relationship. But advisors can play a really important role for early stage companies. But I've been called worse.
Well, the other mistake I see sometimes is they give a little bit of equity, they do investing, but they give way more than they should.
I think that's right.
And that's another case, Kit, where if someone you give them, 0.25%, or maybe 0.5%, depending on how valuable you think they're going to be and what kind of commitment they're willing to make. But hey, if they turn out to be great, you can give them more. You can always give them more. So you don't have to shoot your whole wad at the very beginning and then find out it was a mistake.
Agreed. Okay. Let's see how we're doing time-wise. Okay, so think about where to go from here, what we want to talk about. We can talk about raising capital. We can talk about employees. Kit, do you have any preferences to which way we go from here? If not, I'll do it.
Yeah, no.
No? Okay, cool. Actually, let me go a different direction on IP, because all these companies are really just IP driven. And so I think it's important to spend one moment on sort of the critical mistakes that companies made, because I'll bet if I went around this, everybody would have some pretty good mistakes that our clients and friends have made on the IP side. And so, I mean, I will say as the introduction that I think it's essential for startups to come up with what we call an IP strategy, figuring out, okay, am I going to pursue patents? I only have so much resources. I only have so many dollars, and so when I combine that with the concept of the huge decisions, am I going to pursue patents or copyright, or what's my trade secret? Because some of these are contradictory. Because if I disclose it, then I've blown the trade secret. But on the other hand, so I mean, so the idea is to come up with a rational way in which you're going to create the protection going forward. It's also important to make sure you own the IP. But let me go to start with David. Maybe what mistakes if you were to pick the biggest mistake you've seen the clients make on this side of it, what do you think of this?
Well, I would just step back one step from where you are, David, because you're kind of presupposing that the company's been formed and they have the IP. Now they have to figure out what to do with it.
Yep.
I have seen just way too many situations where people have been working together on a project. Doesn't necessarily have to be in the university, but they've been working on a project to create something. And as Tom pointed out, if you're an inventor, you're an inventor. So they come up with something, but there is no binding commitment. There is no founders agreement or anything that requires them to contribute this IP to a company to be formed. And people have disagreements and they have arguments. They can't agree on the equity. How about that? They've been working on this project. They're all inventors. But when it comes time to sit down and slice the pie, they cannot agree to it. And now no one can move forward. You can move forward because if you're an inventor, you have rights in the IP, but they're not exclusive. So this company cannot say to investors in the future or to acquirers, we own, all right, title, and interest in this IP. And that almost can kill the company, probably usually does kill the company from day one. So I think it's really important that when people start working together, start inventing things, that, we get this commitment, we form this company as soon as we can, or we get some kind of binding commitment that they're going to move forward as a company.
And that goes forward, right? It's not just the founders, but to emphasize what maybe was said before, make sure that every employee and every independent contractor assigns their IP to the company.
Oh, yes.
So you have it so
Absolutely.
that going forward, you have that absolute commitment, because when people go do the due diligence later and everybody says, all right, show me all the invention assignments, and they ain't there, that's a problem. If somebody has not assigned, particularly in the independent contractor, which you don't own it by law. So
Right.
so it's a problem. So I totally agree with you, but let's emphasize going forward, it's something you need to keep in mind all the way along. Employees, independent contractors, founders, you got to get an assignment of that IP into the company.
And I'm just going to chime in from a university point of view, as I see this a lot, that they have these like 5-person team capstone projects. And after the course is over, 1 or maybe 2 actually want to then take what the MVP or what was created during the class and pursue the commercial potential for forming a business. So I would just say that go talk to your other 3 that were on the team and get them to assign it before they leave the university, because finding them later is almost impossible.
Can I add a couple of comments? It's, I think I concur with everything that you folks have said, but it's very much industry and technology specific. And across our portfolio, we've been involved in both extremes. On the one hand, a pharmaceutical company, the IP is everything. The IP is essentially 100% of the value of the assets that you create. But on the software side or the algorithm side, it's much more challenging. Another company that we're involved with, Immunetrics, has, and Reed will remember licensing that original patent application to us. The challenge with computationally based companies is, number one, if you want to have a patent, you're going to have to, the purpose of a patent is disclosure. That's the original purpose, to benefit society. And the compensation you receive for your contribution to society is a period of exclusivity, but you've advanced scientific knowledge. When it's a molecule, that's one thing. If it's an algorithm, providing it's even patentable, that's another thing altogether. So there are other forms that some companies then have to fall back from patents, at least as IP, into other forms of sustainable competitive advantage. It might be the first mover advantage, it might be branding, it might be just an incredibly sneaky business and marketing plan, but not everyone has the benefit of IP as their sustainable competitive advantage.
I'm not sure about the sneaky marketing plan, but okay.
I'd just like to weigh in about a common error I see. So we have, companies that go through our accelerators. It's a requirement that all the team members sign confidentiality and invention assignment agreements. So oftentimes, so they have all these things that are prepared by lawyers, everything's well papered. Then time passes and they'll come back to us, say in a year or 18 months for further investment. And I'll do the due diligence, and they have failed to use the agreements that were prepared for them. They haven't required their subsequent contractors or employees to sign these agreements. And I would just say it happens with amazing frequency. One of the companies that this happened with, they were immensely successful. They were ultimately sold, but they had this gap period where they had not collected these agreements, and the acquisition did go through, but their valuation was significantly reduced because of that gap.
So let's emphasize that's huge, right? I mean, that's huge. So let me make one comment here, which is that we touched on, I think, two of the three IP issues. One is Dave and Deborah talked about a lot, which is making sure you own the IP. Tom talked about protecting the IP. The last one is making sure you're not infringing somebody else's IP.
Oh, great point.
So I do think that it's important because I have had situations. One in particular that always comes to mind, which is when we found that this company that was operating, actually their business model infringed somebody else's patent. And the good news is that they could work around it, but the bad news is a lot of people lost a lot of sleep, and there was a real concern. So it's important when you're going through your process of your business to look at what IP is out there, what patents are out there, and not just for purpose of patenting sort of on the offensive, but on the defensive, making sure you're not infringing somebody else's patent along the way.
I think one of the problems, though, we have to face, David, and we've all been there, is the cost of doing that. When patent lawyers or even patent agents are filing a patent, they'll do a prior art search.
Right.
And that's important because sometimes you're going to find, and this happened with a client of ours, they had a fantastic idea. Trouble is, someone else had that fantastic idea exactly 1 year before. I mean, dead on. And so there was no way to get around that. So that was over. I'm sure that was incredibly disappointing to the person who had come up with it. But that's not such a big deal. The expenditure to do the prior art search is within reason. But when you do a freedom to operate search, that can be $35,000, $50,000, $75,000. And generally an early stage company isn't going to expend their funds for that. Maybe when an investor comes in with a couple of $1 million, that's an insurance policy, if you will, to do that freedom to operate search. But it's a real balancing act before how much money you're going to spend to find out whether you're infringing, or are you just going to swallow hard and do something. Certainly, the inventors usually are pretty good with patents and they can go look themselves, but you're never really going to rest easy until you've done that freedom to operate search.
So I agree with you that most startups can't afford and don't do a freedom to operate. That you can't afford it. But your last comment, I think, is something they should do and they don't do, which is the poor man's freedom to operate. Which is that if they go on the Patent Trademark Office website and go spend a few hours looking around and at least look for the low hanging fruit, and if you find patents, and they know better than anybody else, than our patent lawyers, is that their area, right? So go search around different names, common names, and then if you find a patent or two that are of concern, then you take those to the patent lawyer and let them look at the claims, compare the claims, look at those, and figure out whether it's an issue or not. And I agree with you. You can at least sleep maybe halfway through the night as opposed to not sleep at all. So it's sort of, and so you ought to at least take that step. That's sort of the point. Yeah, but I agree. Freedom to operate. I still can't afford one. Cool. Do we have a question in chat room that I ignored? Let's see.
Oh, yeah,
I think somebody already answered it.
Yeah, I answered it. It was a question, a good basic question though, of when should the entity actually be formed, and I sort of popped in there and said.
Okay, cool. All right. All right, how are we doing time-wise? Let me open up to other questions because we have to. I think we're done at 6:30. So let me open up to other questions, things people want us to talk about before we move on. Okay.
I'm going to pick on Reed. a little bit, because I think that he sees, particularly some of the startups at the earlier stages, what they do wrong with their, before they file their disclosure, before, as what's going through when you're assigning the IP to the startup.
Yeah, so starting with the invention disclosure, a lot of like research groups, labs will just say, inventorship is equal. That's just how we do it in the lab, in our lab. And then when we actually get to like, we're doing a deal, money's on the table, it's like, wait a minute, I actually did 80% of the work. That other person was only marginally involved. And I just did that to be nice. It's like, well, now you need to undo that. So like, get it right the first time. And that plays out in other ways as well, where like the faculty member will be overbearing and say, I'm an inventor in everything that comes out of my lab. It's like, maybe you are, maybe you aren't. It's a legal question, not like a power question or a, respect question. So you can't just fudge those things and say, we do it equal, or I'm an inventor in everything.
It can get a little tricky, Reed, as you know, when you have the head of the department and a graduate student, and the graduate student has probably done most of the work and is the one who's going to spin off the company. And maybe he's got a support, or she has a supportive head of the department, and maybe not. And sometimes it can be very difficult to reach a meeting of the minds between the faculty member, the graduate students, maybe other faculty members, about who's going to be part of this company and who isn't, and what are they going to own, and who's going to stay behind and just take, part of the split agreement of the compensation that comes back to the faculty. Who's willing to actually leave that faculty position and work for the company? Are they going to do it full-time? Are they going to do it part-time? And now we get into vesting. So you open up a whole labyrinth of issues that have to be addressed before you can even launch the company. And we've been through this with someone recently, and we got to an answer, but it took a really long time to get to that answer.
Yeah, and I will just chime in, because I've heard Reed talk about this, that when you actually file the disclosure for who did what on the patent, if you don't get it right, or you're not honest about it, or you add somebody else that hasn't really there because they're trying to get some credits, you can invalidate the patent, right?
Correct. I mean, that will invalidate. So, and I was going to say that, which is to emphasize that inventorship is, if you get that wrong, the patent can be invalidated. And unless somebody should think about it, we have filed to invalidate patents based upon wrong inventorship. And so what a wonderful bonus for a competitor to realize that you can invalidate their key patent because they had the wrong inventorship on it. So it's critical.
Again, I just want to play out, the next stage after the invention disclosure, when you're setting up the company. And again, you have this whole power inequality between the professor and the PhD student. Sometimes there's an outside entrepreneur and so on. In many situations, the professor will say, this is based on my 10 years of work. You as a PhD student have only been involved in the past year. And it's all on my reputation. And if this company's going to go, it's because you're living off, my life's work. But really the value of the company is not in so much the technology coming in the door, is what you do with the technology. So that's an arduous conversation to get the faculty member to realize, if they're only putting in a couple hours a month, they're not the ones that are building the success of the company. And they shouldn't be rewarded as much with the equity as they might think they should be, just based on their reputation and years of contribution to the field.
So I would just say, if you're having that problem, come see Reed or me. Usually you have to, we have data that shows what, from an organization that only invests in university IP startups, that shows what's typical for how much equity the faculty gets versus the PhD that's going to now quit their day, literally go full-time into the company.
That's very good to know.
Exactly.
You may be hearing from us.
Okay.
All right, I think we're coming near the end. Actually, I think we hit the end. So let me see if Tom, David, Deborah, do you want any parting thoughts before we head out the door?
You know, just a real quick one, not to dwell on the emotional aspects, but my advice is make sure this is something you want to do, and it may very well be, and very well may appropriately be. But we had a conversation we touched briefly on, for example, nonprofits. People who are willing to put everything on the line for an idea have actually a lot of ways to do it. It's not just forming an LLC or a C Corp. Those are really important if you want to raise high risk capital and if you'd like the opportunity for financial remuneration at the end. But if it's an idea that deserves to be broadly disseminated, there are other ways to do it other than through forming a corporation. So it's always worth weighing that balance against all the other factors, and above all, personal commitment, personal desire, personal drive.
Good thought. Yeah.
I guess my parting thought would be make sure you understand like kind of your key company documents. For instance, if there is vesting, like the example Kit provided of like understanding exactly if there are timing issues, if steps need to be taken to get certain approvals, you know, in your bylaws, vesting, etc. That's critical. You can't rely on others all the time.
I guess my parting thought circles back to what Dave started with. You know, what is it you are trying to achieve here? And I would posit, and I would think the other panel members would agree. If it is just to make money, you may succeed. But if it's to really, I don't know, change the world, might be a little strong. But if you have a passion, a vision for your idea and what you can do with it, and you're not so focused on the money part will follow. So it ain't just about making money. You really have to believe in yourself and believe in your product, and frankly, believe in your team.
And I guess my last parting shot would be to take off of that is to listen and take and I don't know, you have to take advice, but at least listen and be open to hearing what other people are doing. You know, it's a heavy burden starting a company and doing it, and it's long hours and really hard. And you look around and you're the only one around, or you and your teammates. So finding good advisors, finding other whether it be professionals or advisors or other people that have been there and done that, and talking with that, and having a group around you upon whom to rely, I think is it bounce things around is huge. And I think you will avoid mistakes that some of which we talked about, many of which we haven't talked about, most of which we haven't talked about. And to be able to avoid some of those is really huge. So build your network and use it, I think, is my parting shot, to avoid the kind of mistakes that we've talked about.
So thank you. For our panelists, and David for putting together the panel. This session is being recorded, and within a week or so, it will be on the Big Idea Center's website, as well as in the Short Center YouTube channel under Workshop Archives. So if you want to listen again, or say, this is what they said we should be doing, and we're going to be making one of the biggest mistakes. So let's go back and listen to this presentation. So this concludes our Start Smart Legal series for the spring. And so stay tuned for the lineup next fall. Remember, all these presentations, with exception of one, are recorded. The PowerPoint presentations, when they are used, are on both of the PIT and the CMU websites.
Thank you.
Gee, kid, I didn't know we could bring PowerPoint.
And I intentionally, yes.
Yes. Yeah. So this was a chat.
I want to thank David. Thank you for having me on
Oh.
the panel, David. This
Oh.
was a fantastic discussion.
Oh,
Really
thanks.
good.
It was fun. Thank you all. Thanks.